I'll call the second case now, deLottinville versus State of Minnesota. Ms. Jacks, you've reserved 10 minutes for rebuttal. Right. You may proceed when you're ready. You can feel free to lower whatever you need to there.
To go.
You can lower the actual podium itself, too, if you want to, if that makes it more easier.
I think I'm good.
Okay.
I think
All
I
right.
had issues with that once, and so
All
I'll
right.
just pass on that
Okay.
option. Thank you. Good morning. May it please the court. My name is Sharon Jacks, and I'm the Assistant State Public Defender representing Leona deLottinville. Ms. deLottinville asked this court to reverse the Court of Appeals opinion and affirm the district court's order suppressing evidence that was discovered in a home where she was staying where the officers entered without a search warrant. The federal and state constitutions do not permit police officers to enter homes without a search warrant to execute an arrest warrant for an overnight guest. The Court of Appeals here and the parties all agree that the U.S. Supreme Court adopted that rule. The U.S. Supreme Court adopted that rule in Steelgold versus United States. But the Court of Appeals didn't apply that rule here because it found a distinction in that Ms. deLottinville is the defendant guest, where the defendant in Steelgold was a resident. The Court of Appeals, in doing that, ignored established law that Ms. deLottinville, as a guest, had an expectation of privacy in Mr. Rummel's home. She is not asserting the rights of Mr. Rummel here. She is asserting her own right to have privacy in his home that requires a search warrant, and that it has the added benefit of also ensuring his rights are fully protected. That is what this court intended in BRK when it held that social guests, in fact, have a reasonable expectation of privacy.
Let me just drill down on the precedent here. Having read both briefs, the conclusion that I have reached, you should correct me if I'm wrong, I'm often wrong, but my understanding is that there is no either federal or state case directly on point holding as you wish to hold here. We have to get there by extending existing jurisprudence. Am I right or wrong about that?
You are wrong in that there are courts that have held this. The First Circuit has in United States versus Young, and there is also.
I was thinking of Supreme Court decisions.
No, U.S. Supreme Court, no Minnesota Supreme Court. U.S. Supreme Court has explicitly left this question open, and that was in Steelgold, and Steelgold was decided before Minnesota versus Olson. At which point the court recognized an overnight guest's right to an expectation of privacy in the home of the host. And the Steelgold.
So is your interpretation of Olson that that's just not for standing, but that gives this guest sort of a privacy right that's coextensive with the hosts, the homeowners?
Absolutely, the guest has an expectation of privacy in the host's home. And that's under BRK and Olson. They both have expectations of privacy. It's not a matter of one having more or less. What Olson makes clear is that the host has a superior right of exclusion of individuals, and the right to privacy is not the same as or is not dependent on the right to exclude others. And that's why in Payton, the U.S. Supreme Court held that it was constitutionally permissible to permit officers to enter an individual's home if they have an arrest warrant, because the court held that if a judge has found probable cause that a person has committed a felony, then it's constitutionally reasonable to require that person to open their door to the police officers. It's different in the context of a guest, because a guest has an inferior right to exclude people from the host's home.
Counsel, what was the First Circuit citation that you just made?
The First Circuit is, it was United States versus Young. We did file a letter with supplemental authorities, and it was in there. Okay. That letter also included other courts that have applied this rule. The Eighth Circuit, which has applied the rule that a search warrant is required unless there's reasonable belief that the individual is a resident. The Tenth Circuit also has applied that rule.
Would it be fair to say the overwhelming weight of the authority in the Federal Circuit Courts of Appeals goes against your client's position?
I would say it does, and the reason for that is that the analysis of most of those cases is, I would say, superficial. Those cases all rely on this notion that, they start and end on the basis that a individual should not have more privacy in the guest home, excuse me, where they are a guest than in their own home. And that's not what's going on here. Under Payton, what the U.S. Supreme Court recognized was that that person with the arrest warrant cedes their authority to exclude people from the home by dint of the arrest warrant, and therefore the search warrant is not needed.
Okay. Counsel, let's change the facts of this case just slightly. Let's assume that the officers came to the home without a warrant of any kind. And one officer went around the back and, looking through the glass doors, saw the defendant with a big pile of cocaine and a bong and clearly engaged in illegal activity. Would the officer have authority to enter and arrest the defendant?
No. Under Payton, there has to be either a search warrant or arrest warrant.
Even when the officer is observing a crime, the commission of a crime?
Yes, you need a search warrant to enter. The officer can arrest someone in public if they see them committing a crime. They can't barge into the home and do that. And there might be an additional violation that the officer is on the curtilage of the home without probable cause. So that's a different situation. What happened here was definitely very egregious, because what the officers had was they had an arrest warrant for her. They went to the home of Mr. Remmel, her boyfriend, which was a duplex. They began by first entering, based on the warrant, without consent, the elderly parents' home. The officers testified that, in fact, they felt that they didn't need her consent, that they could just go in because they had the arrest warrant. And then when Mr. Remmel attempted to keep them out of his residence, they entered without a search warrant, without knocking and announcing, and arrested Miss deLottinville. The reason that the Stegall search warrant requirement should apply in this situation is to prevent exactly that type of police conduct. The Stegall court indicated that it was adopting the search warrant requirement in order to prevent police abuses, such as using an arrest warrant as a pretext for entering homes where they didn't have enough suspicion of some sort of criminal activity. The court was concerned about the harassment of all of the neighbors and friends and family of an arrest warrant subject. So it instituted this warrant requirement that is equally needed here. It also has the added benefit of providing officers with a clear and consistent rule. Under the Court of Appeals rule, officers now enter a home, find evidence or not, and will not know whether or not they needed a search warrant until they attribute the evidence found to one person or another. And if they attribute it to the guest, then they didn't need a warrant. And if they attribute it to the host, they do. So the Stegall rule really should be applied in this context as well.
Counsel, is the rule you're proposing limited to homes, or would it apply also to business places, hotels, and so on? What is the precise rule of law you're proposing?
It's limited to residences. That's what Payton and Stegall are limited to, but hotels are deemed to be residents in the Fourth Amendment context, and so it would apply equally there. The the rule that we're proposing here, as I said, is the rule from Stiegel. It's a rule that the First Circuit has adopted. It's the rule that Professor Lefebvre says makes the most sense, again, because the Stiegel rule will have little effect in preventing police abuse if it's not applied in this context also. And it really places very little burden on law enforcement. The Stiegel court said precisely that the fact that although obviously there's an additional burden, this requirement of a search warrant doesn't eliminate officers' ability to arrest the person. They can knock on the door and ask for consent. If there's exigent circumstances, they can enter. They can stay outside of the dwelling and surveil the area until the person leaves. Or they can get a search warrant, which the U.S. Supreme Court said was a minuscule additional burden. And since McNeely, it certainly is an even smaller burden for law enforcement. Where, in contrast, adopting the Court of Appeals rule here, the potential for police abuse is not prevented. And importantly, as this court recognized in BRK, the host's privacy rights are not sufficiently protected. The search warrant requirement here has the added benefit of ensuring that they are. Under the Court of Appeals rule, for instance, if your grandmother is having a Thanksgiving dinner and invites the grandchildren, and one of the partners of the grandson or the granddaughter has an arrest warrant, nobody has any awareness of this. Under the Court of Appeals rule here, officers could simply enter the grandmother's home with nothing more than an arrest warrant, and that's what the Stiegel court was clearly trying to prevent.
Counsel, your reference to Professor Lefebvre, we took a close look at Professor Lefebvre's statement, and it looks to me like he's referring to entry without any kind of warrant whatsoever. And I think the Second and Seventh Circuits have microanalyzed Professor Lefebvre's statement and have come to the same conclusion. Can you make the contrary argument?
Yeah, I think if you go back and read it, I don't know that I can find the exact quote this very second. I can find it on rebuttal.
Professor Lefebvre does not have the force of law, but it was an interesting
Absolutely.
argument.
It's very persuasive, and I disagree with that reading of it. Professor Lefebvre explicitly says, and I can find the quote for you, with neither a arrest warrant or a search warrant. I think that the circuits that have read that differently have parsed out a certain language, a certain sentence out of the paragraph without reading it in its entirety, or that's my reading of it. And he makes a good point. He says Stiegel would become a nullity. That might be an overstatement, but it is certainly true that by only requiring the search warrant when the defendant is a resident, the defendant is a resident, it really does undermine the desire in Stiegel to prevent police misuse of arrest warrants.
So as a practical matter, what should the officer have done once he saw the defendant through the glass?
Well,
can you describe exactly in terms of constitutional law enforcement what sequence the officer should have followed?
As a practical matter, what the officers should have done before they even trespassed on the curtilage of the home was to, after receiving the double hearsay tip from the Meeker County that apparently, it's alleged here that perhaps it was from the ex-husband, that they should have gone to a judge after obtaining more information about who this tipster was and presented that to the judge and asked the judge for a search warrant indicating.
So they should have left the premises,
they should have never
gone to get the search warrant, and then what would happen?
I'm backing up. They should have never been there in the first place. They should have sought the warrant after they got the tip. That's what the case law states. But were they not to do that, and then they arrived, and then they trespassed on the curtilage and looked in the window and saw her in her underwear. What they could have done at that point was knocked on the door and asked if she would come out. They could have gone and sought a search warrant. There were multiple officers there. One of them could have stood outside and basically stayed and watched and waited for her to leave because she was going to put on her clothes and go to a court date, but she was prevented from doing that because of the arrest.
Is it your position that it's of constitutional significance that the officers trespassed on the curtilage?
I raised that in my PFR and I got shut down, so I'm not going to push that too hard. I acknowledge that's not before the court.
I was just
but
wondering
it is
if that had any
concerning.
significance in the context of the argument that you are making.
It has significance into, really the flagrancy of the police misconduct here. They did not have a search warrant. They did not knock on the door. To the extent they got in upstairs, they didn't ask consent of the elderly parents in the upstairs unit. Once they got in illegally into the parents' home, Mr. Remmel told them they couldn't go downstairs into his apartment, but they entered anyhow. And significantly, there was no knock and announce. And the 10th Circuit has held, and I did provide the court with that case, U.S. versus Weaver, that the violation of the knock and the announce rule in the context of a patent violation in and of itself requires exclusion. So there were a lot of things the officer could have done, and that's what the U.S. Supreme Court said in Stiegel. Stiegel said, yes, this person is a moving target when there is a subject of an arrest warrant, but really that doesn't make it a significantly different situation than when you're seeking to enter to find contraband, because there's so many options for the officers. And so the U.S. Supreme Court imposed the search warrant requirement, understanding that there was a little burden on law enforcement and that it would provide, additional protection for the host, and in this case, the guest. And as I say, that looking at your case in BRK, you had expressed great concern with respect to a host's privacy rights, and that an expectation of privacy must be recognized for the guest in order not only to protect the guest's privacy rights in that home, but to fully ensure the privacy rights of the host. And that's what the search warrant requirement would do here.
Counsel, let's turn to the state constitutional argument if we could. Every time I look at Kahn versus Griffin, I wonder more and more about its clarity. But what kind of custom, practice, tradition, Minnesota element here pushes this over the line so that we could carve out greater protection within Article 1, Section 10 than afforded by the Fourth Amendment?
Yeah, certainly BRK is the most relevant case. Davis and Carter both recognized greater expectations of privacy than the Fourth Amendment had within an apartment, within a storage unit, by requiring reasonable suspicion before permitting a dog sniff. But BRK is really the case that drives the need to require a search warrant requirement here. BRK recognized that in Minnesota, even if under the Fourth Amendment a social guest does not have an expectation of privacy in the home, that under the Minnesota Constitution, that person does have an expectation of privacy. And the rationale for that is, again, to fully protect the privacy interests of the host. And that's precisely the reason why the New Jersey courts recognize that under the New Jersey Constitution that the Stiegel rule should apply equally to the guest as well as a defendant, as well as the resident as a defendant. So yes, under Minnesota we have a history of providing greater protection of the Fourth Amendment generally, more specifically within the privacy of the home, and very, very specifically here in this exact context. The search warrant requirement here, it achieves the outcome that was intended by your decision in BRK. So,
Counsel, does the record tell us whether Ms. deLottinville knew that there was a warrant out for her arrest?
I would say that there is very little information about that in the record. There is one statement in a defense memo that would indicate that she did. There's also an indication in that memo that the warrant that the officers had was not a warrant for a new felony, which is what is really required under Payton, but it was actually an arrest warrant
For revocation of probation, right?
It was for a violation of a release condition, and she had a dirty UA. So there was not, like in Payton, a judicial determination of probable cause that she had engaged in new felony activity, and therefore she forfeited rights to exclude people from her home. In fact, this was a warrant that didn't even need a judge to find probable cause of a probation or of a release condition in order to issue it, because under the rules, under Rule 6, it's the warrant issues on an agent's statement of probable cause of a violation. So, you know, in this case, I'd encourage you to take the opportunity to clarify under Payton and Steele Gold also, you know, what type of warrant really triggers this rule. Because in the end, officers are entering an individual's home without a search warrant. And that is not something that should be done lightly. Obviously, that's the main purpose of the Fourth Amendment, is to prevent these illegal entries. And even if at this point this court clarifies that under the Minnesota Constitution and the Fourth Amendment, no warrant is in fact required, it can't be said that the court here clearly and unequivocally erred. And so you must still reverse the Court of Appeals decision and affirm the district court. If you review the findings of fact for clear error and the determination of whether or not a search warrant was required here de novo, you still have to get to the final step in the analysis under the pretrial appeal standard of review, and that is to determine whether the district court clearly and unequivocally erred.
Counsel, are we back to that issue that the court has under advisement in Lugo?
Exactly.
Which is whether on a question of law, you have to demonstrate, the state needs to demonstrate some kind of super clear error?
Exactly. I mean, and that's what I understand that there's some what's perceived as conflict in your precedent on that, but I would say under either of the cases, under Weber or under OTHA, even if you apply the OTHA standard of review and review the legal issue de novo under these facts, and in this case, there still can be no clear and unequivocal error, because unlike the facts in Lugo, the issue here is an unsettled legal issue. The question is whether a search warrant was needed or not. You review that de novo, you decide, we disagree with the district court. We believe that the search warrant here was not required. You have to look at the district court's order then and say, well, was the district court clearly and unequivocally erred?
So your proposal is we say the legal question is unsettled, therefore affirmed.
Exactly. You cannot say that the district court violated any established law in its decision, because as Justice Anderson said, there is no established law on this. The U.S. Supreme Court left it open. You've left it open 2 or 3 times. Court of Appeals.
9 federal circuits have not left it open.
And 3 went our way. So, and we have Professor Lefebvre on our team. So,
does that count for 1 or 2 circuits?
Possibly 3.
Maybe 3, yeah.
So even if we only have 1 circuit, there is no clear and established law on this. And so this court here, this judge, did not clearly and unequivocally err. And therefore, we'd ask you to reverse the Court of Appeals decision and affirm the district court.
Thank you, counsel. You have 10 minutes for rebuttal. Mr. Weeks.
May it please the court, my name is Samuel Weeks. I'm acting as Special Assistant Meeker County Attorney today, and I'm representing the respondent, state of Minnesota.
Counsel, can you just put the microphone up a little bit? There you go. Thank you.
Yes.
Thank you.
Sorry about that. When a judge issued an arrest warrant for Leona deLottinville, the judge gave his judicial stamp of approval for law enforcement to enter a location where Leona deLottinville had a reasonable expectation of privacy and to effectuate that arrest. I don't disagree with Ms. Jacks. Ms. deLottinville did have a reasonable expectation of privacy in her boyfriend's home. But under the Payton decision, law enforcement could have gone into Ms. deLottinville's own home to effectuate that arrest because of the arrest warrant. Why should she get more protection in her boyfriend's home than she gets in her own home?
How about because Stiegel says that an arrest warrant does, quote, absolutely nothing to protect the homeowner's privacy interests in being free from an unreasonable invasion and search of his home?
There are two different bodies of law that are being argued in this case. The Stiegel case applies to, in this case, it would be Mr. Remmel. Mr. Stiegel was a homeowner in his case, and there was not an arrest warrant for him. It was for another individual. Mr. Stiegel was protected in that case, and Mr. Remmel, if the issue comes up for him, is able to assert his rights under the Stiegel decision.
Well, Stiegel suggested that the homeowner isn't protected by bringing a lawsuit or that the Fourth Amendment is there to prevent illegal police actions or unnecessary intrusions into a privacy right. Isn't that correct? I mean, I understand that you can read Payton and Stiegel to say, well, Stiegel applies if it's the homeowner who's complaining. And Payton is, Payton shows that deLottin doesn't have a privacy right when she has an arrest warrant that's been issued by a judge to, exclude someone from her own home. But I think there's a real question about whether Payton can be extended to our situation.
Well, I understand that, and that's why we're here today. I'd argue that Mr. Remmel is still protected in this case, even if Payton is applied to Ms. deLottinville. There were contraband items found inside the home, and if charges are brought against Mr. Remmel, he may assert the court's decision in Stiegel and be protected under the Fourth Amendment. He does also have the opportunity to bring a civil action, even though there was some question about that in the Stiegel case under 42 U.S.C. 1983 for a violation of his civil rights. The Payton decision doesn't leave him completely unprotected. It doesn't allow law enforcement to go knocking down doors anytime they have a whim that somebody might be inside that home. Law enforcement has to have...
But Stiegel said that it actually happened. There had been a case where there had been 300 entrances into people's home based on an arrest warrant, apparently. I think that was in Stiegel.
My understanding in Stiegel was...
The facts of that case, but they referred to another matter when they were talking about potential police abuse of using an arrest warrant to gain entry to an innocent third party's home.
Well, and I understand there's the argument that there's potential police abuse, but that's why there's a probable cause standard that limits officers' ability to enter the home. That's greater than a reasonable suspicion that Ms. deLottinville was inside the home. In this case, they had to have probable cause to know that Ms. deLottinville was there. And in this particular case, they had greater than probable cause. Agent Brannis knows Ms. deLottinville from prior contacts, saw her through the window, immediately recognized her, and knew that she was in there. The same factual scenario has been brought up, as was mentioned earlier, in many different jurisdictions. And in each case where the facts are similar to this, where the arrest warrant is for the individual inside the home, and law enforcement has probable cause to know that the person is in there, every court has found that law enforcement was allowed under Payton to go in there. Stiegald has been addressed in those cases, and it has been found in all of those cases that Stiegald may apply to the homeowner or the resident of the home, but does not apply to the guest with the reasonable expectation of privacy. The appellant did cite to the U.S. versus Young case, which came out just a couple of months ago from the First Circuit, arguing that that was an exception to the string of cases that have been decided, as I'm asking this court to decide. I would argue that that is a different case. The facts in that situation had the law enforcement officers having a tip that the person might be in there or might be in any of 4 different locations. They went into the home, and only after they'd entered the home without permission did they gather the information that allowed them to have probable cause to know that Mr. Young was inside the home. That's different than this case. Agent Brannis did not enter the home until he had actual knowledge that Ms. deLottinville was inside the home. And so I would disagree with Ms. Jacks that all of the cases that have been decided by other jurisdictions still do agree with the decision I'm asking this court to reach today.
So you're saying Young was a no PC case?
Yes.
No probable cause to enter the home?
At the time they entered the home, they had reason to have a suspicion, but they did not have probable cause. They had a suggestion that he might be in any of 4 locations, and they saw his girlfriend's car outside the home. Later, someone saw him through a window, but that was already after other officers had entered the home, already after the breach had occurred. So, yes, I am arguing that there was not probable cause in that case. And that's the difference between this case before the court and the Young case.
Same question for you, counsel, that I asked of opposing counsel. What does the record tell us as to whether Ms. deLottinville knew she was the subject of an arrest warrant?
I believe, as Ms. Jack said, she did know she had court, and I believe she indicated in a statement to law enforcement that she was aware that the warrant was out there.
Counsel, isn't it?
Sure.
Isn't it accurate that she was on a conditional release? The terms of the conditional release were that she had to stay sober and that she had to do UAs. And she had multiple UAs, more than one, that were either diluted or dirty. Correct?
I did not work on that particular case, but that is my understanding.
Which then violates the conditional release, which they're informed when they sign the conditional release can result in an arrest warrant.
Yes.
I'm not sure if it's of constitutional significance, but it seems to me it's one thing when you go to grandma's house not knowing that you're the subject of an arrest warrant and the officers all of a sudden burst in and destroy the Thanksgiving dinner. It's another when you go to grandma's house carrying that knowledge of that arrest warrant with you. And then I guess the next Thanksgiving is going to be a really bad Thanksgiving. Is there any significance in her knowing that she had an arrest warrant out for her?
I don't know that there's any constitutional significance, but I can see that certainly making a difference to how Grandma feels about the individual later.
But how does that help protect Grandma's right to bar police from coming into her home?
Grandma still has the ability to have anything suppressed that would be found by law enforcement. She still has the opportunity to file a 1983 action for violation of her civil rights.
But that's after the fact. Those are all after the fact. They're not going to prevent an unexpected and perhaps frightening intrusion into her home based on somebody else's wrongdoing that she may or may not know about. I mean, because we're deciding this case not only on the basis of the facts of Miss deLottinville. I mean, those are important, but this is a rule that's going to apply to every Minnesotan. Somebody could come into your house if you had if you had a person who had an arrest warrant at Thanksgiving?
I would agree that those are after-the-fact remedies, but most remedies for potential constitutional violations are after-the-fact remedies. The potential for receiving a lawsuit may cause a law enforcement agency to alter its individual policies for how they handle a situation like this. In a larger jurisdiction, law enforcement may have the opportunity to place people around the perimeter of the home and go get that search warrant that Ms. Jacks wanted law enforcement to have in this case. I'd argue, though, that's not possible in every case. Perhaps here in Ramsey County, where there are a lot of law enforcement agents, they would have the manpower to surround the house and send somebody to go write up that search warrant. But we're talking about Meeker County here. Meeker County is a large geographic area with a very small population. As such, it would typically have 2, maybe 3 deputies on duty on a weekday morning. The Remmel home is located in a rural area with woods near it. If there are only 2 people available, one person could watch one side of the house, but there are multiple exits. It's just not possible to watch every possible exit and keep Ms. deLottinville there and to go get that search warrant. The judge has already put his stamp of approval on an arrest warrant to go in and arrest Ms. deLottinville. A court order is a court order, and that arrest warrant does temporarily suspend her expectation of privacy in that location, or at least her protections of that expectation of privacy.
Counsel, let's assume we disagree with you, decide this evidence was seized unlawfully. Would we then have to remand for proceedings on the good faith exception to the exclusionary rule recognized in Lindquist?
I will admit I'm not familiar with the Lindquist decision, so I can't speak competently to that. However, if the evidence was already excluded in this case, I believe that that would settle this case. One other point I would argue is that the concern here is for the rights, the concern I'm hearing from the court is for the rights of Mr. Remmel, the homeowner for whom there is not an arrest warrant. The arrest warrant, while it does allow law enforcement to go in and arrest Ms. deLottinville, only grants law enforcement limited power. The arrest warrant lets them, if they have probable cause to know she's in there, enter the home, arrest her, and get out. If they happen to see something in plain view while they're in there, that's a separate issue, and that's how this case ended up happening.
But doesn't that, counsel, create an issue? I mean, the fact of the matter is it's one thing if deLottinville has something illicit, but it's a whole other thing if the homeowner has something illicit. So he's now, or she, allows the police into the home and you know, absent that arrest warrant, those police would not be in the home. And so does that really raise a problem under your view?
No, it doesn't, because that is the protection provided by the Stiegald case. Mr. Remmel, who didn't have the arrest warrant, can assert that there was no reason, or that he is protected under that decision from the entry of law enforcement, anything they happen to see in that case. Ms. deLottinville, however, does not have the ability to assert those rights. They're two separate bodies of law that would apply to the 2 different situations, even though it's one course of conduct in this case.
Counsel, then how would you respond to Professor Lefebvre when he says that Minnesota versus Olson, quote, lends considerable support to, and I'm not quoting exactly here, but a conclusion that the visitor can also object to the absence of a Stiegel-required search warrant? Why isn't that right?
I would argue that the situation that Mr. Lefebvre is referring to in the Olson case is again, different than the situation in the present case. This is a narrow situation that we're arguing here. In the Olson case, there was neither an arrest warrant nor a search warrant. Law enforcement went in with probable cause to believe he'd committed a crime, but without that judicial stamp of approval to go in despite his expectation of privacy. In this case, they had that stamp of approval in the form of the arrest warrant to go in for that limited purpose.
Counsel, let's talk about the state constitution. Doesn't opposing counsel have a point that under BRK and some of our other state constitutional jurisprudence, we do seem to care in Minnesota more for expectations of privacy in residences, whether hosts or guests or residents generally? And so isn't there some kind of custom, practice, and tradition of extending more protection under our Minnesota Constitution in these circumstances?
Well, I certainly recognize that this court has the ability to do that and can do so if it so chooses. But again, I'd argue that the BRK decision is also a different situation because, again, they did not have that stamp of approval in the form of the arrest warrant to go in and, in that case, search the individual who ended up being the subject of the case, BRK.
So you're saying that our custom, practice, and tradition has to do with whether or not there's a warrant
I'm saying that
of some sort?
I'm saying that the situation referenced in BRK and this situation are different. As for the customs and practices of this court, I do recognize that the court can interpret them differently, but this court has stated on several occasions that when the language in the federal and state constitution is similar as they are here, I believe they're the same, then it would have to be a rather exceptional situation for that extension of the rights to be made for the purpose of the state constitution.
And why isn't this case exceptional? What, fitting this in against the background of our state constitutional jurisprudence on Article 1, Section 10, what makes this unexceptional?
The arrest warrant. Law enforcement had been given the authority to go in despite Ms. deLottinville's expectation of privacy in this case. I would also point out that this court has adopted the Payton decision and affirmed it on several occasions since it came out in, I believe, 1980. This is...
Well, we don't really affirm U.S. Supreme Court decisions.
Adopted.
We respect them, follow them.
That is what I meant. My apologies. What I'm arguing is this is the Payton decision has been respected in Minnesota law, and this is not. I'm not asking for an extension of the powers of the police under Payton. This is just a different application of the Payton standard. In the cases that have been cited, there was not an arrest warrant in BRK in Olson. In this case, there was. There was an arrest warrant for Ms. deLottinville, which allowed law enforcement to go in spite of her expectation of privacy and her rights under the Fourth Amendment and Article 1, Section 10. And this court has stated on numerous occasions that constitutional rights, particularly as it pertains to search and seizure, are personal rights and cannot be vicariously asserted. As this case pertains to Ms. deLottinville, the defendant who was subject of the arrest warrant, she had no expectation. She had an expectation of privacy, but law enforcement was allowed to go in spite of that expectation of privacy to effectuate her arrest. One other point I'd like to address is the standard of review question that I believe was raised and was addressed by my opponent. Again, it was acknowledged that that question is a little bit up in the air in Minnesota because of the Lugo decision that is pending. But I would point out the standard of this court has been that constitutional issues are decided de novo. I believe that was the Wolf decision, and that this case is a constitutional issue before the court. Questions of law are also subject to de novo review under the Gouster decision, and there aren't any real disputes as to the facts in this case. This is purely a question of law before the court. So the standard of review should be de novo as this court reviews the situation here. One other question that I was anticipating is that why not just get a search warrant? This question has come up at every level of this case so far. As I said before, it's not possible in all situations to get a search warrant. In Meeker County and many western Minnesota counties, there are large areas with small populations and not a lot of deputies on the staff that are able to do that.
Counselor, are you essentially making the equivalent of an exigent circumstances exception in this context? Because I don't think that was an issue on which we granted review.
Not an exigent circumstances issue. I am just arguing that the court has pointed out that just because it's inconvenient doesn't mean that law enforcement shouldn't get
well, you're not asking for a Meeker County exception or a rural exception to any warrant requirement, are you?
No, not a particularized exception. I'm just pointing out that the standard is that while it may be just because it's inconvenient doesn't mean that they shouldn't have to do it, but in some cases it's not just inconvenient, it's impossible. It would depend on the situation, just like this case depends on the facts of this case.
What effect, I mean, maybe the better argument, not to give you an argument, but what effect would this have on the state to require the state or officers to get a search warrant? So to get a search warrant, you need to have probable cause that you're going to find evidence of a crime's been committed. But what if you heard from two sources that so-and-so with an arrest warrant is having Thanksgiving dinner at grandma's house? May not really be probable cause, doesn't rise to that level, even though you strongly suspect it. Would that hamper the ability to effectuate arrest warrants and allow people to sort of hide out? Or, I mean, I'm just trying to figure out what the real-world implications of this is. And, you know, I would ask opposing counsel, from her perspective, given her experience, whether there's real-world, you know, consequences going the other way.
The, excuse me, the search warrant, there wouldn't be probable cause to believe a crime was being committed in grandma's house simply by the presence of somebody with an arrest warrant. So by that standard, a search warrant wouldn't be appropriate. But if there is probable cause to believe that the subject of the arrest warrant is in grandma's house, then I believe that for the limited purpose of effectuating the arrest, law enforcement should be allowed to go in and arrest that person and then get out as quickly as possible. And if the concern is the rights of the homeowner, an arrest warrant is far less invasive for the homeowner in this situation than a search warrant would be. An arrest warrant allows them to go in, grab Ms. deLottinville, and get out, which is exactly what happened in this case.
Counsel, I think what Justice Strauss was getting at, though, is that let's say that we agree with your opponent and come up with a rule of law that an additional, a search warrant would be required in this scenario. What impact does that have, i.e., would it allow individuals who have warrants out for arrest to be able to essentially hide out or to stall or to lay in wait in other families' homes rather than being in their own residence? I think that's the point that Justice Strauss was asking you, and if you could comment on that.
It would certainly make it a lot easier for an individual on the run to simply couch surf at friends' houses, and law enforcement would need something more to get that stamp of approval to go in and do a search warrant because of the invasiveness of the search warrant for the homeowner. So yes, it would give great incentive for an individual to go on the run, to hide out in numerous locations and make for law enforcement, make their job much more difficult to effectuate an arrest for a person that has been deemed by a judge necessary to be arrested.
Well, and that
Well, I
brings up
suppose the argument-
can I ask one follow-up? So that brings up an interesting point, though. I wanted to ask, so presumably you're going to be able to get a search warrant that covers any place where you can find the person, right? I mean, because that's how search warrants are. So if you're looking for drugs, you can get a search warrant to look in somebody's drawer for drugs. Same thing would go for a person. You can look at closets, you can look at whatever. I'm wondering what your rule is with regard to arrest warrants. If you believe somebody's in there, now I know here you look in and you see the person, but I'm wondering whether that allows you, suppose you look in and the person's sitting there, but then the person goes and hides in a closet. Under your view, does the ability of the state extend to any place that you can have an arrest or a search warrant for, or is it more limited than that? I'm just trying to figure out how these rules interrelate between the search warrant and the arrest warrant.
Yeah, my time is up. May I be permitted to answer the question?
Please, yes.
The practical application of the arrest warrant would still be more limited than the search warrant. The search warrant would allow law enforcement to go look all over the home for that individual. The arrest warrant would still allow law enforcement to go in, but if the person saw the cops coming and ran and hid in a bedroom and they weren't sure where, it should still allow law enforcement to go in and find that person. It's still a limited search. Once they find that person, they have to get the person out of there. Limiting it to the arrest warrant limits the invasiveness of the search and the invasiveness to the homeowner in this situation.
Thank you, counsel. Your time has expired. Ms. Jacks, you have 10 minutes for rebuttal.
Excuse me. The Stiegel court addressed some of these issues that Justice Strauss and Justice McKeague are raising with respect to the difficulty of obtaining a search warrant, and really rejected any concern about that, or that it would encourage flight by the subject of the arrest warrant. What the court said was that particularly in this context, what officers would need to show is probable cause that the subject of the arrest warrant was in the location. And so here what the officers had was a tip. They would have to gather more information about, the source of the tip and the basis of knowledge for the tip, and then present that to a judge. The protection, one of the protections that the search warrant would provide would be that it would limit the scope of the search, unlike the arrest warrant where, the officers can go in and really there's a lot of potential of abuse of going beyond just finding the person. Here it appears that from this record that the officers simply went in, arrested, saw items in plain view, and left. They didn't do any sort of search beyond that. But one of the bases for advocating a search warrant requirement is it makes very clear to the officers what they can and can't do once they enter the home. And again, what the Stiegel court said about the idea that this is someone who's going to be moving around and is a fugitive and so shouldn't be provided with this protection, the court said, there really is very little extra burden on law enforcement. There is some, but because there are so many different opportunities to arrest this person, the constitutional requirement that that people not have their homes invaded really has to win out over the small additional burden to law enforcement.
But even under the state's rule, I'm questioning this a little bit, because you're right that if the search warrant says you can only look in the kitchen for whatever reason because they believe or in the basement because they believe he or she's sleeping in the basement, that's one thing. But it seems to me that even under the state's rule, you can't, like, for instance, the police are trying to find a fugitive. They can't go in and look in somebody's, kitchen drawer, bathroom drawers and look at their personal items and things like that. Am I wrong about that? I would think that would be struck down if anything was found in a drawer that clearly can't fit a person.
I think that would violate even the Court of Appeals rule that was adopted here, yes, absolutely. As far as factually in this case, I just want to point out that the omnibus transcript does indicate there were 3 to 14 officers on the scene that day, so there certainly was no concerns about not having enough officers to have someone stand outside to see if and when Ms. deLottinville would leave or knock on the door and ask if they could come in. As far as United States versus Young, that decision did not turn only on the officer's lack of probable cause that the defendant was inside, but also the lack of probable cause that the person was a resident, and that was the basis for the court suppressing the drugs found against that person.
One of the concerns might be here that typically we don't allow one person to assert, like in this case, Ms. deLottinville, to assert the Fourth Amendment rights vicariously of Mr. Remmel. And I just want to make sure that I understood. I think you discussed that previously, but I want to make sure I understand your authority for sort of making that rule not apply.
Under Olson and under BRK, she, as a guest in the home, has a reasonable expectation of privacy. And so she is asserting her right to not have that privacy invaded with the lack of a search warrant. In this situation, because she's a guest in a home, her assertion of that right has the added benefit of also further protecting the privacy rights of the host, but she is not uniquely asserting that person's rights, Mr. Remmel's rights. It's just, as I say, an additional protection that is afforded, and that is precisely the result that this court wanted in BRK, was that you recognize the right of the social guest to assert privacy rights in the home that they're visiting so that the host's rights are fully protected.
Counsel, what would your response be to Mr. Weeks's point that in BRK, the difference that he seemed to draw was that there was no search warrant for BRK, whereas in this arrest warrant, for BRK, and in this instance, there is.
Exactly. I mean, I think with respect to the question before the court, that's really irrelevant. I mean, the question before the court is, does she have a reasonable expectation of privacy? Yes. It was settled law at the time of BRK that no warrant meant can't come in. Here, it's our position that no search warrant can't come in, so she can assert those rights. But BRK doesn't really bear on the issue of whether a search warrant is required or not. If the court has no further questions, I'd ask that you reverse the Court of Appeals and affirm the suppression order in this case.
Thank you, counsel. Thanks to both counsel for the help that you provided to the court in this matter. This case is submitted. We'll issue an opinion in due course. We're in recess.